So a challenge to the ATF's ban on bump stocks is now heading to the Supreme Court. So let's talk about this. But real quick before we jump into this video, if you think that the ATF should be abolished, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main sponsors of the channel, and that is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. So the case we're talking about in this video is Aposhian v. Graywall, and it is a case coming out of the 10th Circuit. In this case, all involves a challenge to the ATF's recent arbitrary redefinition of what a machine gun is and treating bump stocks as a machine gun under the definitions of the GCA and the NFA. So for some quick background on this case, how it ended up here and what this all involves. Well, for many years, the ATF had correctly concluded that the NFA and the GCA's definition of the term machine gun did not include devices like bump stocks. However, after the tragic event in Las Vegas on October 1st of 2017, the ATF, after being ordered by former President Trump, decided to arbitrarily change the regulatory definition of a machine gun so that bump stocks would be considered to be machine guns under that definition. This final rule by the ATF took effect on March 26th of 2019. Therefore, under federal law, owners were required to either destroy the devices or to surrender them over to the ATF offices prior to the effective date of that new rule. The plaintiff in this case is Mr. Aposhian, and he purchased a slide fire bump stock prior to the ATF's final rule. When the ATF issued their final rule, he filed a lawsuit against the various government officials and the agency itself, challenging the ATF's final rule as unconstitutional. Before the district court, he sought an injunction against the ATF's enforcement of their new definition of what a machine gun is. The district court denied his injunction, and the denial was then appealed up to the 10th Circuit. A 3-judge panel in the 10th Circuit ultimately upheld the ATF's ban on bump stocks. Plaintiff then sought a rehearing en banc in the 10th Circuit, which is a review by a larger panel of judges instead of just a 3-judge panel in the 10th Circuit. The 10th Circuit did decide to hear the case en banc, but then randomly decided to vacate that rehearing, which essentially means they decided out of nowhere to just not hear the case by the larger panel of judges. After the 10th Circuit vacated their rehearing en banc, plaintiffs in this case, Mr. Aposhian, then sought a cert petition up to the Supreme Court, where we find ourselves now. In the cert petition, there are 3 questions presented to the Supreme Court. The first question presented is whether courts should defer under Chevron to an agency interpretation of federal law when the federal government affirmatively disavows Chevron deference. And don't worry, we're going to cover what Chevron and Chevron deference is in just a second. The second question is whether the Chevron framework applies to statutes with criminal law applications. And finally, the third question presented to the Supreme Court is whether, if a court determines that a statute with criminal law applications is ambiguous, the rule of lenity requires the court to construe the statute in favor of the criminal defendant, notwithstanding a contrary federal agency construction. So those are the 3 questions presented to the Supreme Court. Now let's take a look at the cert petition and what this all involves. When you look at the cert petition, there are really 2 main things that pop up: questions revolving around Chevron deference and the rule of lenity. So the first issue is whether or not the ATF waived Chevron deference. So let's cover what Chevron deference is. Chevron deference is a term coined after the landmark case Chevron USA Inc. v. Natural Resources Defense Council Inc., referring to the doctrine of judicial deference given to administrative actions. And what this means is when a statute is ambiguous and a federal agency has the ability to implement that statute, is that federal agency allowed to interpret that ambiguous language, and what deference should be given to that agency's interpretation of that ambiguous language? And how Chevron deference interplays with this issue here is the definition of machine gun under the GCA and NFA. The question is whether or not that term machine gun is ambiguous or not. And what's interesting here is when you read the cert petition and the arguments before the 10th Circuit and the lower courts is that the ATF actually says that the definition of what machine gun is not ambiguous. In fact, they say that the machine gun definition is very clear and that it covers things like bump stocks as well. However, courts have found that that language could be ambiguous and has therefore given Chevron deference to the ATF, despite the ATF actually saying that they didn't rely on Chevron deference, that they didn't need Chevron deference because this term was not ambiguous. However, the courts have still imported Chevron deference and given deference to the ATF's interpretation of that term. And so one of the issues presented to the Supreme Court is whether or not the ATF has actually waived their ability to claim Chevron deference. And if the ATF did waive Chevron deference, could a lower court then use that, still despite the ATF waiving it, in giving essentially the ATF the benefit of the doubt in their interpretation of what a machine gun is? Because the issue is that some courts will still apply Chevron deference in favor of an agency, even when the agency directly denies Chevron's applicability in the case, like the ATF did. The second main thing presented in the Sur Petition to the Supreme Court involves criminal statutes and the fact that Chevron does not apply to criminal statutes. The argument is that the interpretation of statutes with criminal implications should be left to the courts themselves, not to agencies like the ATF. This all revolves around the fact that the NFA, the GCA, and the definition of machine gun does have criminal implications attached to it. If you are found in possession of what the ATF is defining to be machine gun, there are criminal penalties attached to that. And so should the ATF be able to arbitrarily interpret definitions however they want and then apply criminal penalties and enforce those criminal penalties against individuals? And so the argument in this section is that Chevron deference does not apply when you're dealing with issues involving interpretation of newly created crimes. So essentially the ATF cannot be allowed to 1, create criminal laws through interpretation of vague statutes, 2, then enforce its own newly created laws, and then 3, receive judicial deference from courts in their application of those laws. If something like this is allowed, then the ATF could simply make up new laws through interpretation whenever they want, enforce those laws, and apply criminal penalties against individuals without any oversight. And so the second section of the Sur Petition is all revolving around criminal statutes, interpretation of criminal statutes, and essentially what leeway should an agency like the ATF have in interpreting these criminal statutes and then applying them against individuals. And the last section revolves all around the rule of lenity and whether it should actually be used in these types of issues. And so the argument in this section is that courts do not need to lean on Chevron deference in looking at the ATF's interpretation. Instead, they can use a different type of canon of construction, which is the rule of lenity. Here, the confusion around the definition of machine gun under the GCA and NFA and whether the definition includes bump stocks can be resolved if you use the rule of lenity. Under the rule of lenity, when dealing with criminal statutory interpretation, which we're dealing with here, a court is required to apply any unclear or ambiguous law in a way that is most favorable to the people, not the agency. So the argument here in the Sur Petition is that the rule of lenity is a better way for the courts to look at this ambiguous term machine gun. And using the rule of lenity, they should err on the side of the people instead of erring on the side of the ATF in their arbitrary redefinition of what a machine gun is to include more things and then subject people to more criminal penalties. Now let's look at some of the major impacts that this case really does have and how a decision by the Supreme Court on this case really trickles down to other very big issues. The main ones that probably come to a lot of your guys' mind is the recent redefinition of frames and receivers by the ATF, and then the redefinition and the proposed rules around pistol braces in treating any type of firearm with a pistol brace as an SBR, and then subjecting those firearms to the rules and regulations of SBRs being a tax stamp and registration. This does not just directly impact those frames and receivers proposed rules by the ATF or the pistol brace proposed rule by the ATF, but also can stop the ATF from doing future interpretations and arbitrary interpretations to bring more things under their control, which we've seen the Biden administration call for the ATF to do heavily recently, in which they are now kind of taking up that mantle, and we've seen them do with frames and receivers and pistol braces. A decision by the Supreme Court here could stop future arbitrary interpretations by the ATF. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you guys like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm. It helps to signal to YouTube that you guys see value in these videos, in this type of two-way news, and then it pushes it to more individuals. As you guys can see through my recent videos, you guys are having a huge impact on the algorithm, on this channel, on my videos, and you guys are pretty much just destroying the algorithm, and it is forcing YouTube to push these videos to more individuals and to spread this type of two-way information. So I cannot thank you enough for doing that. If you guys don't have a comment in mind, just drop down a comment below saying, hey, I'm commenting to fuel the algorithm. That really does help, and you guys will see me in the comment section commenting back to you guys. And also, if you're a new subscriber, go ahead and comment down below that you're a new subscriber, and I will make sure I comment back to you. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.